case study we completed was that of VeallvVeall, which took place in the appeals court. The main individuals concerned in this case were the testator Arthur Keith Veall, the appellant Arthur Roland Veall, who was the testator's eldest son from the first marriage, and his wife Alexis Jane Roche Veall, and the respondent Kim Louise Veall, the testator's youngest daughter from his second marriage. So the facts of the case were as follows. The testator, Arthur Keith Veall, died on the 13th of October 2011 at the age of 91 years. He had 2 children from his first marriage and 1 child from his second marriage. Now, previously in his wills, the testator appointed his 2 eldest children from his first marriage as the executors of his will, and he made a number of limited legacies, including his prized shotguns that were to go to his 2 grandsons, the sons of his youngest daughter Kim. He'd also divided his residuary estate equally between his 3 children. However, in his final will, the testator appointed his eldest son and his daughter-in-law as the executors of his will, and redirected the specific legacies away from the previous intended beneficiaries, such as the shotguns that were instead to go to his eldest son Roland. He also divided his residuary estate between his 2 eldest children to the exclusion of the youngest child from his second marriage. The testator also made express mention of some shares that had been his largest asset. However, the testator held those shares in a trust, and those shares had been disposed of by the trust several years previously. This case began when the trial judge refused to admit the will to probate, believing that despite the testator's impaired cognitive abilities, he did have testamentary capacity. However, the trial judge was not satisfied that the testator knew of and approved the contents of the last will. The appellants filed a notice of appeal against the trial judge's finding on knowledge and approval. The respondent filed a notice of contention of the order dismissing the proceedings be maintained. The appeal court held that the testator did not have testamentary capacity and also did not know and approve the contents of the will.
VeallvVeall, the appellants had argued that Keith had testamentary capacity, Keith being the testator. They opposed Kim being the respondent on the fact that Keith lacked capacity, knowledge and approval of the second executed will. The appellants argued that Keith was aware with the contents of the will and he did have testamentary capacity.
Now, the appellant, Kim Louise Veall, lodged a caveat in that proceeding as she objected to the will being admitted to probate. The appellant agreed with the trial judge's decision that the testator was not aware of the contents of the will. However, she disagreed that the testator was of sufficient mental capacity during the writing and signing of the will.
The trial judge found that he had capacity, so agreed with the plaintiffs, but agreed with Kim on Keith not knowing the contents within the will. However, on appeal, the judges agreed with Kim, being the respondent, on both matters. One being that Keith, in fact, did not have testamentary capacity and was not familiar with the contents within the executed will. Furthermore, the executor of the last will appealed against the trial judge's finding on knowledge and approval, and the other party appealed against the finding that the testator had testamentary capacity.
The legislation which provides for the circumstances under which a will is to be considered valid and the appropriate steps to be taken when an individual is considered to not have testamentary capacity are listed within the Wills Act 1996. Additionally, the Administration and Probate Act 1958 provides a jurisdiction under which the court may grant probate of the will or administration of the estate of any deceased person in Victoria. The test to be used to determine whether an individual is of testamentary capacity is that of Banks and Goodfellow, 1870. The 4 steps are that an individual must understand the nature and effect of the will, understand the nature and extent of their property, comprehend and appreciate the claims to which they ought to give effect, be suffering from no disorder of the mind or insane delusion that would result in an unwanted disposition.
Common law also shows the importance of considering of sound mind in the process of a will. Banks vs. Goodfellow identified that the person must understand the nature and effect of the will, understand the nature and extent of their property, comprehend and appreciate claims to which they sought to give effect, be suffering from no disorder of the mind, insane delusions that would result in an unwanted disposition. In this case, in VeallvVeall, they had to evaluate whether Keith's mental issues interfered with his ability to understand the will, even though the solicitor had explained it to him. I believe VeallvVeall is a significant and appropriate case on the examination of a testator's capacity and understanding of a will. The measures used in this case, which are generally thresholds, medical examinations and assessments, concluded that Keith's ability was severely restricted due to health issues. Therefore, I believe the judgment on trial and appeal were momentous and acceptable in circumstances that both trials met the standards by applying thresholds to each situation.
Part 3 of the test of Banks and Goodfellow adds morality to the creation of wills, which displaces the freedom which should be inherent in will making. An individual who does not consider their moral obligations does not necessarily mean that they do not have testamentary capacity. While it is suspicious that the testator's will deviated from his previous wills, it is not enough to consider it suspicious merely because in his final will he excluded his moral obligations to his youngest daughter and her sons. Part 4 of the test outlines the need to ensure the testator is of sound mind. The VeallvVeall encourages the practice of legal practitioners, medical practitioners, and psychiatrists, combining their expertise to develop an accurate assessment of the testator in order to ensure their wills are made with sound mind and are free from undue influence. The decision of the appeals court in VeallvVeall was made in conjunction with the evidence presented of the opinions of medical professionals, which assessed the testator as having vascular dementia. While he was capable of lucid intervals, the testator's mental capacity deteriorated around the time of the creation of the will. The lack of cooperation between the solicitors involved and the medical professionals overseeing the testator's condition led to the inevitable doubt concerning the testator's knowledge of the contents of his will and his testamentary capacity.